Hello and welcome to a special interview for The Wire. How credible and convincing is the evidence on the basis of which the Supreme Court has given the entire land of the Babri Masjid to Hindus? Or does it raise worrying questions which could even point in a disturbing direction? That's the key issue I shall explore today with the Vice Chancellor of the Nalsa University of Law and one of India's great experts on the Constitution and law, Faizan Mustafa. Professor Mustafa, I want to start by quoting what the Supreme Court itself has said in its judgment on how it's approaching the Babri Masjid issue. In paragraph 796, the Supreme Court says the dispute is over immovable property. The court does not decide title on the basis of faith or belief, but on the basis of evidence. So let me start with a general question and I'll come to specifics later. How credible and irrefutable is the evidence on the basis of which the Supreme Court has given the entire site to Hindus?
Karan, Justice Deepak Mishra started as a civil suit. He said it is a civil suit. Ideally, it should have gone to a 3-judge bench. And CJI Gagoi unnecessarily constituted a 5-judge bench. And then you know that Justice UU Lalit had to withdraw because Dhawan said you had appeared for Kalyan Singh. I feel the moment you send it to a 5-judge bench, that means you consider it more than a civil suit. But in the end, after saying that they will go by evidence, they did consider and attach a lot of importance to belief and faith.
So you're saying to me that although they claim, as I've quoted in paragraph 796, that they will only decide on the basis of evidence, you believe they've actually decided on the basis of faith as well?
Yes, because if you look in terms of writing of judgment, it is very well written judgment. It looks like that they are deciding on law, making all good statements. But at the end, the belief of a group is given a lot of importance.
So you're also saying to me that this claim the Supreme Court makes, that they will only decide in terms of evidence, is one they have not lived up to?
Yes, it has not been entirely decided on the basis of evidence.
Let's then come to specific issues at this point. Now, the Supreme Court says that post-1857, both Hindus and Muslims have provided evidence of worship at the Babri Masjid. But prior to 1857, this is what the Supreme Court says of Hindus. On a preponderance of probabilities, there is evidence of Hindus worshipping in the inner structure. But when it comes to Muslims, the court says, there is no account by them of possession, use or offer of namaz in the mosque between the date of construction and 1856-57. Nor is there any account in the evidence of the offering of namaz in the mosque over this period. Now, the peculiar thing is, after saying this, the court acknowledges repeatedly that this is a mosque. It accepts that it's been in existence for over 450 years. So if it's a mosque, doesn't it automatically follow namaz must have been had there?
If it is a mosque, there has to be a presumption that prayers are being held. Anyone who says that prayers were not held has to prove it. But this was not an issue which was framed there. In the High Court, no evidence was led on this issue. Karan, this case is all about wall and railing.
I'll come to the wall and railing later. Let's just take this step by step because it's very important. So you're saying to me that when you accept a structure is a mosque and you accept it's existed for 450 years, the presumption is that there has to be prayer said there.
Right, of course.
Then let me put this to you.
And we should also presume that a Muslim will not pray in a place where idols are there.
Let me then put this to you. If the court believes there is no evidence of Muslim prayers in the mosque from its date of construction 1528 till 1857, then presumably the court is also suggesting that this was a defunct or disused mosque.
In that case, the record would show, because in the record in Punjab, you have hundreds of defunct mosques. But then the record would speak for it.
So there is no record that shows that between 1528 and 1857, the Babri Masjid was a defunct or disused mosque. There's no such record.
There is no such record.
And secondly, even though the court claims there is no evidence of worship happening in the mosque between 1528 and 1857, the court doesn't go on to say, therefore the mosque was defunct or disused.
It doesn't say so. It rather says that it was a mosque for 400 years.
So here the court is actually contradicting itself. On the one hand, it says it's a mosque that's existed for 450 years. On the other hand, it says for 325 years, there was no prayer. Now that's a clear contradiction. You can't be a mosque and have no prayer. And if you have no prayer, then the court has to accept it's defunct, but the court doesn't accept that either.
Correct.
So the court here has actually contradicted itself.
Yeah, because it admitted later on in the judgment that it was a mosque for 4 centuries.
Let's just explore this point one step further. After asserting that for over 325 years no prayer was said in the mosque, or at least there is no evidence of prayer in the mosque, how does the court explain the fact that suddenly in 1857 prayers are happening? Because the court concedes that post 1857, prayers are happening. How does it then accept that?
Karan, it's not a question of evidence, it is a question of documentary evidence. Prior to 1856, no documentary evidence was there. The issue is, if you are claiming possession, you don't need to prove it for 300 years. If you prove it for more than 12 years, it is done. So there was no documentary evidence, but there was a presumption. There has to be a presumption. And on the basis of that presumption, the court itself said that it was a mosque for 4 centuries.
You're saying two very important things. I'll slightly unpick them for the audience. First of all, you're saying that if you're claiming possession, you don't have to claim possession and show proof of possession for 450 years. 12 years should be sufficient. In fact, in this instance, the court accepts that Muslims have shown possession from 1857 onwards.
At least.
At least. Secondly, you're also saying that if it is a mosque, you have to presume prayers were there. And if you believe there were no prayers, then you have to prove there were not. The onus is actually on the Supreme Court to prove there were no prayers, not for Muslims to prove there were prayers.
In fact, somewhere in the judgment, they also talk of section 57, which says that the court takes judicial notice of certain acts. Now, if certain facts are taking judicial notice of, no evidence is to be led. For instance, you say in a court, sun rises from the east. No evidence is required. So, if it is a mosque, court accepts it as a mosque, it has to take a judicial notice that prayers were held.
And in fact, the second anomaly in the court's reasoning is that after asserting there is no evidence of prayer from 1528 till 1857, suddenly you get evidence from 1857 onwards, but the court doesn't ask itself, why is there evidence suddenly available now? It just accepts it without questioning why that happens. That too is something the court should have logically questioned in its reasoning.
No, because the record is now available.
Which it wasn't earlier. So purely on that narrow basis that there is no documentary evidence, the court has claimed, therefore this wasn't a functioning mosque earlier.
It seems like they are saying that they have not proved that they were praying. They accept it is a mosque, but they are not saying that they were also using it for prayer.
While we are talking about what I call anomalies or inconsistencies or even illogical errors in the court's reasoning, let me point out one more. The court accepts that in 1856, 1857, there were Hindu-Muslim rights over the right to worship at the Babri Masjid, as a result of which the British constructed a railing to create separate spaces for Hindus and Muslims. In which case, that means, and this proves, that Muslims were worshipping before 1857. Otherwise, how do you explain the riot?
Of course. Of course. And Karan, I feel that in this case, this railing, since it is a claim about possession, the court said that it does not mean that it decided the title or there was a subdivision of the property, but it is a claim about possession. I tell you that you use outer courtyard, I will use inner courtyard. That's it.
You're saying again a very important thing, the railing, and the fact that there was a riot which led to the railing being put up. A, prove that Muslims were worshipping before 1857, otherwise why would there have been a riot? And secondly, the railing also is
and why would British allow them to use inner courtyard after 1856?
Secondly, therefore, the railing is also a claim of possession. It is both proof of worship prior to 1857 as well as a claim of possession.
Because the court has accepted that no party in this case has proved title.
I want to go
Therefore,
further.
they have to decide on possession, and the railing is crucial.
I want to move on, but let's very quickly sum up what we have so far discussed. One, we've established that if the court says this is a mosque and accepts it's been in existence for 450 years, then the presumption is that it was a functioning mosque where prayers were said. Secondly, if the court believes that there is no evidence of prayer and therefore there is no prayer, then the court has to go on to say this was defunct or disused, which the court doesn't say.
I will add one more thing. The mere fact that the British grant paper was on record, the British will not give a grant for the maintenance of mosque if mosque is defunct.
That's another point that the court seems to have overlooked. And finally, the third anomaly is that the court accepts that there was a riot in 1856, 1857 over the right to pray at the mosque, and yet doesn't believe that this riot proves that Muslims were praying prior to 57. It has to logically, but the court doesn't accept that argument.
Right.
Let's now move further. Finally, the court relies upon 18th century accounts by European travelers such as Joseph Typhon Thaler, William Finch and Montgomery Martin for evidence that Hindus were praying prior to 1857. But all those accounts also mention a mosque, and none of them says that the mosque was defunct or disused. So my question is this: the accounts that provide evidence for Hindus also provide evidence for Muslims, and yet the court seems to be blind to half of that.
Correct. And none of them, of course, Typhon Thaler was, escaping persecution from Portuguese in Goa and was writing 15 years after returning from Ayodhya. He is writing in some 1886 or so while in London. And Martin never came to India. The point is that none of them have made a distinction which court has made between inner courtyard and outer courtyard. So when they are talking of temple mosque, they are talking of a whole complex without identifying who was praying where.
Now, secondly, the court has relied upon 18th century accounts by European travelers. Am I correct in saying that there are no Indian accounts in Sanskrit or Hindi which say that in fact the Babri Masjid is the site of the Ram Janmastan?
Before 16th century, there is no single Sanskrit or indigenous Indian account which either treats Ayodhya as holy and sacred because of birth of Lord Rama, or says that there was some Janmasthan which people used to visit. So you have evidence about Samudragupta, you have evidence about Kumar Gupta, 4th century, 5th century, you have evidence of Huan Suang, Chinese traveler, is writing 5 pages about Ayodhya and not mentioning that the most sacred place in Ayodhya is the birthplace of Lord Ram.
So the first such references happen from the 16th century onwards, not before.
Yeah, it will come in the Skand Puran.
And the second thing you're saying to me is that the court has relied upon European accounts. There are no 18th century Indian accounts in Sanskrit or Hindi that claim that the Babri Masjid is the Ram Janmastan.
And the court itself says that these accounts are not to be taken into account for deciding a title. For a glorious Hindu religion and worship of Lord Rama, why should we rely on these travelers rather than our own Sanskrit scholars?
Yet we have.
We have.
One more point. The court's reasoning also seems to fly in the face of history. This is what the court says in its judgment. The Muslims have offered no evidence to indicate that they were in exclusive possession of the inner structure prior to 1857, since the date of the construction in the 16th century. But when the mosque was built in 1528, Babur was the conqueror of India and a very devout Muslim. Later, from 1658 to 1707, Aurangzeb was emperor of India, and many people believe he was a religious bigot. Is it conceivable that they would allow Hindus to worship in a mosque? And that too, a mosque named after Babur, the founder of the dynasty? Or would they have insisted, as emperors, that this is exclusively the property for Muslims only?
I think it is laughable. Babur is building a mosque. There was, even prior to Babur's conquest, from 13th century onwards, you have a record of every single Delhi Sultanate ruler appointing somebody as a governor of Awadh. Babur, while in Panipat, is saying that I have conquered this land, and talks of Awadh and says from Awadh, the revenue which comes is 11,21,563 tankas. It was a Muslim habitation. Amir Khusro lived there for 2 years. Alauddin Khilji, when he chopped off the head of his uncle Jalaluddin Khilji, sent it for display in Awadh. Muhammad bin Tughlaq, when there was a famine in Delhi, went to Awadh where there was a lot of grains available. So you have a history from 13th century to 16th century. Court is wrong in saying that there is a gap in the ASI report. ASI may not know, and their report may not really tell what happened between 13th century to 16th century, but we know, historians know it.
Leave the ASI out. You're making a very important point. You're saying that there is 4 to 5 centuries of Muslim rule in the area of Awadh.
Right.
And you're saying that therefore it's inconceivable that Mughal emperors who were devout Muslims would have permitted Hindus to worship in a mosque.
The Kotwal and a Faujdar of that place. And Awadh was the name, Ayodhya was called Awadh. It was a provincial capital. It was impossible that such a prominent mosque would have been used by non-Muslims.
So as you said a moment ago, it's laughable that the court has taken this position.
Right, of course. And why court is not asking that Hindus had the exclusive possession or they were exclusively...
Let's take this step by step. You're saying first of all that the courts stand, that Muslims cannot prove that they had exclusive possession is laughable. It's impossible to believe that at a time when Muslim emperors who were devout Muslims were ruling in this area of Awadh, where the mosque is located, they would have permitted Hindus to worship in a mosque. You're saying that's laughable.
Court itself said that the Muslims have not abandoned the mosque. If you have a Muslim habitation there, then Muslims will go and pray. Had it been proved that there were no Muslims in Ayodhya, I would have assumed that probably mosque became defunct.
But therefore you're saying to take this position when there was total Muslim rule is laughable. You use that word laughable. I'm just asking you to repeat it. It's laughable.
I'm saying, of course,
laughable.
When you are having rule of great Mughals, and when you are having Saadat Ali Khan founding a powerful dynasty in Awadh in 1722, to say that this mosque was not used by Muslims is laughable.
Let me then come to another aspect of the Supreme Court's judgment. The Supreme Court views the Babri Masjid site as a composite whole. But from 1857, it was quite clear that there was a demarcation between the inner courtyard and the outer courtyard. Now, the Supreme Court's explanation for viewing the two courtyards as a composite whole is they say that even when Hindus prayed at the outer courtyard, they would do so looking at what they considered the Garbhagriha, which they believe was under the central dome, which they believe was the exact spot where Ram was born. Do you accept that as a justification for overlooking the fact that from 1857 these were two separate areas and view them instead as a composite whole?
Give me half a minute. You have a house here and I am your neighbor. I pray on my roof and I am directed towards your house. Can your house become mine? This wall business is very important. ASI ignores the western wall with Taq and Mehrab, which was a proof of a Qanati mosque, on which there is a whole book by a Japanese writer about Delhi Sultanat's Qanati mosque and Eidgahs. And now you have a wall put up by British which divides possession, and you say while you are on the other side, you are not given possession of this. Just because you stared at this side, you become owner of this side as well.
So you're again suggesting that this claim that because you looked across the wall, because you believed that the Garbhagriha was on the other side of the wall, therefore you have a right and a claim to it.
So Muslims
and therefore the two which were separate from 1857 onwards should be considered as a composite whole. You're saying again,
it cannot be considered composite whole. All Muslims in India are praying towards west. Does that mean that every property on the west becomes Muslims' properties?
Is this once again, to use your word, laughable?
I would say to say that just because somebody was standing on a land given under his possession, was looking at the land of somebody else, becomes entitled to possess that land as well. I think it will become laughable.
Let me now come to certain important questions that have been asked about the judgment since it was delivered roughly 10-12 days ago. And I'll go through these questions one by one. First of all, the judgment says, on a balance of probabilities, the evidence in respect of the possessory claim of the Hindus to the composite whole of the disputed property stands on a better footing than the evidence adduced by the Muslims. Now that clearly means that both parties, Hindus and Muslims, have provided evidence of their claim, but the court believes the Hindu evidence is better. Isn't that grounds for splitting the site between them, maybe not equally, but in some proportion, rather than giving it entirely to the Hindus?
Of course. The moment you accepted that both were using it, it is to be divided.
And the moment you accept, as the court says, that both have provided evidence, even though you think the Hindu evidence is better, that's grounds for splitting it, not giving it entirely to one party.
Definitely, because when you are talking of balance of probability, that means that there was some evidence, but you considered this is more, the weight is on this side. Maybe it is 55% and other side is 45%.
So then, by giving the whole thing to one side, the court has actually been unfair to Muslims.
I would say, current court, towards the end, I think 799 para, they say it's a 1500-yard place. If both are given, then no one can have a peaceful enjoyment. So court became really pragmatic in giving the final relief.
That's an explanation, but once you concede that both have claims,
You have to give it to both.
you have to give it to both. And if you don't, then it's unfair,
Of course, it is against the principle of balance of probability.
which means it's unfair.
Of course.
Now, the second question which arises from the verdict and the judgment is that the court readily accepts that what happened in 1949 was a desecration of the mosque. It calls the demolition in 1992 an egregious violation of the law. What then do you make of the fact that the very land on which the mosque stood has been given to the party that allegedly violated the law?
There is a finer point. The party to which the land has now been given is Ram Lala Virajman. Of course, he did not violate the law. But one has to accept, since he has been accepted as a juristic person, he did enter the inner courtyard through an action which the court has called illegal in 1949. And it was the same people who are claiming their right to worship him, which the court has now accepted, who demolished the mosque. So people who are the beneficiary of this demolition or entering into the mosque illegally are the beneficiary of Supreme Court's judgment. But you can't be blaming Ram Lala Virajman himself for this kind of thing. Because in 1949, Karan, there was a Havan for 2 months and they said that the idols will automatically go inside. I would presume Ram Lala refused to go inside voluntarily and he was involuntarily taken inside.
That's a presumption on your part. But
It's a fact.
But you're saying a very interesting thing, that the placing of the idols was desecration and a violation of the law. The idol that was placed was that of Ram Lala, and therefore that idol violated the law.
Of course, principal is responsible for the acts of agent, but you cannot hold him criminally responsible. But would you give the entire land to that party? That is the question in a civil dispute.
And again, that is where you say that the court has, in your opinion, erred.
Because it was a case of split of land then.
Now, there's a third question that arises from the judgment, and I will admit that it's a difficult to follow, complicated one. It's been best advanced by K. Venkata Ramanan, writing in The Hindu. And because it's difficult to follow, I'll read what he says carefully. He writes, in the ultimate analysis, the non-interference by Muslims in Hindu patterns of worship in the Hindu shrines, such as the Ram Chabutra and Sita Rasoi, worked against their cause because the Supreme Court was led to believe the Muslim claim was non-exclusionary. Whilst, on the other hand, by repeatedly challenging the Muslim mode of worship, Hindus managed to come across as those with unimpeded possession in the outer courtyard and a partial stake in the inner courtyard too. And what he's really saying is that Muslims were disadvantaged by the fact that they peacefully accepted Hindu rites of worship, whilst Hindus got an advantage because they challenged Muslim rites of worship. Would you accept that this rather strange situation is true?
I would say two things. One, on that very title itself, since you had an inscription where Emperor Babur's name is invoked, and it is said that on his orders Mir Baqi constructed this mosque, Babur has been accepted as a sovereign, so the land belongs to the new sovereign. In Ayodhya itself, in 1994, in Ismail Farooqi on the land acquisition, the court said that the government can acquire any land. So this land's title was with the then sovereign, new sovereign, with Babur. Now, this entire land, adjoining land is also there. The question is that after the end of Mughal Empire, when the British have taken over Awadh, Muslims are permitting others to also come peacefully and pray. For this accommodation and tolerance, you can't be punishing them.
But it seems that's precisely what the
They have
court
been
has done.
punished.
And in fact, the opposite is also true. Hindus challenged, sometimes even violently, Muslim rights to worship at the Babri Masjid. They've got an advantage from that.
3 times from 1856 to 1949, the court has accepted that they tried and the police was called in and the Muslims were permitted to pray. So 3 times they violated law. That violation of law becomes something very, very advantageous for them. I think that this is a new kind of jurisprudence we are writing.
So once again, you believe the court
I
has
think it is absolutely wrong.
absolutely wrong. Now, let's come to Ram Lala. You mentioned Ram Lala a moment ago. It seems all the important arguments advanced by Ram Lala's advocate were actually dismissed by the court. They were: one, that the mosque is illegal; secondly, that a temple had been destroyed to build the mosque; and thirdly, that the Ram Janmasthan is a juristic personality itself. Now, given that all the main arguments of Ram Lala have been dismissed, what do you make of the fact that Ram Lala has still been given the entire land?
Karan, first of all your viewers should know, in this case and even otherwise, Muslims do accept Lord Ram and have lot of reverence for them. Iqbal has called him Imam-e-Hind. They have not disputed that Ram Lala was God or he was not born in Ayodhya. The question was whether he was born exactly under the central dome of Babri Mosque. So they have not disputed Ram Lala's even juristic personality. Dr. Dhawan also accepted it. The question is the 3 main arguments which were made by this new party, because he will enter the fray in 1989, isn't so?
All 3 arguments dismissed.
Are dismissed, but he is given the entire land. This defies logic.
It defies logic.
Yes.
In fact, you pointed out that Ram Lala only entered the picture with a petition filed in 1989. Even the Supreme Court accepts that Muslims were worshipping inside the inner sanctum from at least 1857 onwards, which means that Ram Lala entered the picture roughly 132 years after Muslims started worshipping inside the inner sanctum. Are those grounds for saying that the Ram Lala petition should have been barred on grounds of limitation of time?
Yes, there is absolute unanimity that idols are juristic person in India. So Ram Lala is a juristic person. But law of limitation would apply even on a juristic person. So the cause of action for Ram Lala either arose in 1528 if you accept the thesis that his temple was demolished, but it has not been proved and there is no ASI evidence on this.
Or in
1856 when you say that prior to that probably he was worshipped and now he is not worshipped and exclusively Muslims are worshipping. So he is clearly within limitation.
So when you file only in 1989 and you are filing 132 years after 1856-57, you're saying clearly this case should be barred on grounds of time limitation.
Because what happened, in 1856 court is admitting that now Muslims started exclusive, so cause of action arose. When in 1949, this mosque virtually has become temple, everyday prayers are held, bhog lagaya ja raha hai, and after 1986, locks are also opened, worshippers are also coming. So 1989, there was no cause of action for Ram Lala.
And therefore, that's grounds for saying that either Ram Lala should have filed the petition a lot earlier, and if it didn't, then it's barred by time.
Right.
Now, fifth, the Supreme Court has also ruled that the government must set up a trust which will own the land and will also build the temple. Many people point out this conflicts with the secular status of the Indian state. Do you believe it does?
I don't. Because Article 290A says, out of the consolidated fund of state of Kerala, 46 lakhs 50,000 will be spent every year on the Devasam Travancore temple. And every state is, most states are paying salaries of priests, salaries of imams. So India is secular, but lot of state funding is given to religions. This trust will raise its own funds. Government will just bring it into being, but it will be the trust which will construct the temple, not Government of India.
So here you don't believe the Supreme Court has erred.
No, I don't.
In suggesting this trust, the Supreme Court has not breached the secular status of the Indian state.
I don't think. In fact, had Supreme Court completely given it to Ram Janmabhoomi Nyas, which filed this Ram Virajman suit, that would have been bad, because all these VHP affiliated people were involved in the demolition of mosques. So court did the right thing in my opinion.
Okay, let's
But
now...
government should exclude now everyone who was in any way involved in demolition. We have to see how fair government is in really bringing this trust into being.
In other words, the trust cannot include people who were involved in the demolition.
In any way.
This is therefore a test of the government's fairness.
Yes.
I want to come now to a set of specific questions raised by Justice Ashok Ganguly, a former judge of the Supreme Court. Again, I'll take you through them one by one. Speaking to the Telegraph, Justice Ganguly says, when our constitution came into being, that place was recognized as a masjid. So then the minority community has the right to defend its freedom of religion, a fundamental right guaranteed by the constitution. And what Justice Ganguly is saying is that by giving that entire site to Hindus, the Supreme Court has breached the fundamental constitutionally guaranteed rights of Muslims. Do you agree with him?
Freedom of religion, is not only available to all citizens, but even to foreigners. So everyone has a right to worship. If it is a mosque and a suit number 1 was a Hindu saying, I want to worship Lord Ram here. Similarly, it is a mosque, so Muslims equally have a right to worship there. So there Justice Ganguly is right.
He's right. So in other words, you're saying that by giving the land to Hindus, the fundamental rights of Muslims have been breached by the court?
By giving it entirely to them.
By giving it entirely. If it had been divided, that would be another matter. But by giving it entirely, the fundamental rights of Muslims have been breached.
That is what Justice Ganguly meant when he made this statement.
And you agree with him?
I think he has a point.
Now, Justice Ganguly also makes a second point. He says, and I'm quoting, what was there before the Constitution is adopted is not the responsibility of the Supreme Court. There was no Democratic Republic of India at that time. And again, what he seems to be suggesting is that the court has no business to try and determine pre-constitution titles.
Here I don't agree with him. One, there are hundreds of property disputes which started in British era and they are continuing now and courts have pronounced on them. Similarly, when the Constitution will come into being on 26 January 1950, there were no prayers held in this structure because of that status quo order. Now, worship of idol of Lord Ram was happening, but no Muslim prayers were held on the commencement of the Constitution.
So, on this point, you disagree with Justice
don't agree
Ganguly.
with
Now, Justice Ganguly makes a third point. He says, and again I'm quoting him, who owned the land 500 years ago? Does anybody know? We cannot recreate history. The court has no duty to recreate history. What was there 5 centuries ago, the court is not supposed to know. And yet that is precisely what the court tried to do by relying on what it considers evidence. So is Justice Ganguly right in saying that the court shouldn't have even attempted to try and establish title by trying to recreate or work out what happened in history?
He is right. Why he is saying so? Because court unnecessarily made this observation that because of this controversial ASI report, probably the mosque was not constructed on a vacant land. As I told you, Babur as a sovereign was entitled to this land. He constructed mosque on it and that is the end of the matter. What was there before is irrelevant.
So you agree with Justice Ganguly, the court should not have attempted to try and discover what was there before.
The court itself said that we will not do this exercise. They said that we cannot recreate history. Court admitted it.
So is Justice Ganguly then in your eyes correctly criticizing the court, or is he actually criticizing something that the court didn't do? Which of the two?
You see what happened, the court said this, that we will not go back to history.
And then did it.
Then they did it. That's why Ganguly's criticism.
So in other words, once again the court has done what it said it wouldn't do, and this is why Justice Ganguly is right.
Right.
This is just like the earlier point you made. The court began by saying it will only decide in terms of evidence, and having said it, it actually has tilted in favor of faith. Here again, after the court said we won't go back into history, that's precisely what the court has done. These are two instances, therefore, of the court contradicting itself.
Right. And it contradicted few days later when in the Sabrimala case, there was a question, one argument was that Sabrimala was not a Hindu temple because peoples of other faith come and worship. And then Justice Chandrachud and Justice Nariman said, so in a church, if people of other faith come, it still remains a church. So this contradicts the argument. If it was a mosque and Hindus also sometime prayed there, it remains a mosque.
Quite right. The comment made in the Sabrimala case, if
just
you
4 days later.
if used in the Babri Masjid case, would actually contradict the conclusion the judges came to in the Babri Masjid case.
Right.
Now, Justice Ganguly says, and I'm finally quoting him, either I would have directed the mosque to be rebuilt in that area, or if that area is disputed, then I would have said no mosque, no temple in that area. You can build a hospital or a school or anything like that, or a college. How do you respond to that?
We don't live in an ideal world. The judges were pragmatic rather than idealist.
So
it was impossible to construct a mosque there. Even if judges had given this land to the Sunni Waqf Board, Muslim intellectuals and liberals would have forced Sunni Waqf Board to give up this land for the construction of Lord.
What about the second part of what Justice Ganguly is saying? He says either I would have constructed or rebuilt the mosque there, or I would have said no mosque, no temple, build a hospital, build a school or a college. What about that?
It's difficult in view of the sentiments of the people of majority. I think it was very near impossible to do it.
Let me then finally come to what I suspect is Justice Ganguly's conclusion. And again, I'm quoting him. He says the judgment has chosen the Hindu faith over the Islamic faith. Do you agree?
It looks like, unfortunately, many experts believe so, and if this is so, it is unfortunate.
Do you, because you're an expert on law and the constitution, do you believe it?
No, I would say the mere fact they said that one party has to give hard evidence to prove its possession, and the other party's illegal acts or mere assertion that my lord was born there is enough to prove their right is problematic.
Problematic is a euphemism. Is it also unfair?
It's unfair, absolutely, because you have to treat both the parties equally.
And clearly the standard or criterion being used is not equal.
Yeah, you can't have differential burden of proof for two parties.
So in addition to being unfair, is this also wrong in law?
I think it's wrong in law.
And the point you're making, and I'm just spelling it out for the audience, is that Muslims were required to prove that they had exclusive possession of the inner sanctum, whereas in the case of Hindus,
mere assertion was right.
Yeah, bare assertion that by looking that way when we pray, that's taken as possession, whereas Muslims are required to give much harder evidence, and therefore this...
They were summoned to give hard evidence, while for other party, mere assertion or belief was enough.
And as you said, this is A, problematic, B, unfair, C, wrong in law.
Wrong in law because it sets a bad precedent for future.
Let me at this point, and by getting to the end of the interview, raise 3 or 4 other issues which are not necessarily critical to the content of the judgment, but nonetheless they arise either out of the way the judgment was delivered or questions that come thereafter. And I'll again take you through them one by one. This was a judgment of a 5-judge constitution bench. It was a unanimous judgment, and yet the authorship of the judgment has not been revealed. Although the Times of India has done a pretty good job in concluding fairly convincingly that the author has to be Justice Chandrachud, officially the Supreme Court has not acknowledged the author. The judgment is anonymous. What do you make of that?
I think judges should reveal their names.
They should reveal
Yeah,
their
they should
names.
own up their judgments.
It's wrong not to.
And this addenda is not even a judgment.
I'll come to the addenda. Is it wrong not to own up to the authorship?
Difficult to say whether it is wrong, but this is the tradition, and the proper thing is one judge will write the judgment, the others may say we agree with it. So everyone who writes a judgment and signs it must own up his judgment. Our judges take the oath to decide cases without fear or favor. What fear was there in revealing their names?
Let's now come to the addenda. As you said, it's a 116-page addendum, and again, the name has been withheld. But more importantly, although it's presented as an addendum, it actually ought to be a concurring judgment, because this addendum comes to the conclusion the land should be given to Hindus not on the basis of evidence, which is presumably the position of the other 4 judges, but on the basis of faith.
Of course.
So, in a sense, A, the addendum ought not to be an addendum, it should be a concurring judgment. Would you agree?
Yes, of course.
And secondly, the fact that it argues clearly on the grounds of faith, not evidence, actually in a sense reveals that the whole judgment, of which this is now presented as an addendum, actually claims to be on the basis of evidence, but actually is more on the basis of faith.
It's tilting towards faith.
It's tilting towards faith. A third question, do you believe that this judgment has either set a precedent or provided some ground and reasoning for other cases like Kashi Vishwanath or Mathura to be taken up by the Supreme Court?
Two responses. Our government, through its embassies, has issued a statement where the government has said it is not a precedent. Now, if something is a precedent under Article 141, it's binding on all courts throughout the territory of India. Since in this case the court invoked 142, so it will remain only to this case. The court was exercising its power of doing complete justice.
But just a second, it only invoked 142 to give 5 acres of land and to create the trust.
Yeah, right.
But the reasoning is not dependent upon 42. Now, the question I'm asking is the reasoning and the way they have claimed to have used evidence to go back into history to decide who had ownership, could that set a precedent for Kashi Vishwanath and Mathura?
There is a problem. There are two problems. In fact, one, they have said themselves that law court is not the right forum to correct the historical wrongs. So this sentence would say that don't initiate any other thing. Then they say that this Places of Worship Act is part of the secularism, which is the basic structure of the constitution. So there is some moral advice that no other issue should be raised, but court cannot prevent lower courts from entertaining cases, and it cannot prevent Parliament from repealing 1991 Places of Worship Act.
The sentence that you quoted is an important sentence from the judgment. Let me read it out. This court cannot entertain claims that stem from the actions of the Mughal rulers against Hindu places of worship in a court of law today. For any person who seeks solace or recourse against the actions of any number of ancient rulers, the law is not the answer. That set of sentences clearly suggests the Supreme Court, at any rate, is not going to hear more such cases. But as you said, you can't stop lower courts doing it, and you don't know what Parliament seeks to do because Parliament has its own prerogatives.
I'm not confident that such disputes will not arise in future.
Now, I want to come, before I end, to the response of Maulana Mahmood Madani, the head of the Jamaat-e-Ulema-e Hind. He said, and I am quoting, "The Honourable 5 judges of the Apex Court, despite admitting that the placing of idols and destruction of Babri Masjid were serious violations of the rule of law, gave the land to those who had committed such crimes. This is clear discrimination against a particular community which was not expected on the part of the court. The judgment has shaken the faith of the minorities in the judiciary as they believe they have been wrong." I want to ask you just one simple question. You're an equally eminent Muslim and you are an expert in the constitution and the law. Do you believe the faith of the Muslim minority, 14.5% of the country, has been shaken in the judiciary?
Karan, one, Maulana Arshad Madni and Mahmood Madni, they are also in talks with RSS and with government, are trying right now to present the moderate face of Muslims and Islam. So even if they are disappointed, that means that they are reflecting the larger mood of Muslim community. But more than Muslims, and I have written in Hindu and given as many as 8 reasons that there are so many positive observations and findings of the court in favor of Muslims, except the relief, more secular and more people who know law are disappointed with this judgment.
So then, are you saying, because the first half of your answer suggested that the Madanis reflect the views of the community and therefore if the Madanis are disappointed, the community will be disappointed. But the second half of your answer said exactly the opposite. So I'm asking you again for clarity. Do you believe India's 14.5% Muslims have had their faith in the judiciary shaken? Give me a clear answer.
I would say that their faith, to the extent that this false narrative that a Ram temple was demolished to construct the mosque has now been busted, satisfies them.
But what about the fact
but
that
the final relief should disappoint them?
So will the final relief shake the faith of Muslims in the Indian judiciary? Give me a clear answer.
I would say not really, because Muslims have been saying from day one that whatever Supreme Court decides, they will accept.
So you disagree with Maulana Mahmood Madani?
No, you see, any losing party may get disappointed, but to say that their faith in the judiciary as such is shaken will be an extreme view. I would not like to say that Muslims don't trust our judiciary. We trust our judiciary. We think they are independent and impartial.
Now you've given me a clear answer. Faith in the judiciary has not been shaken.
I would say so.
One more point. The Supreme Court has been scathing in the view it's taken of both 1949 and the demolition in 1992. Is it now therefore incumbent on the Supreme Court to ensure an expeditious closure of the case being held in Lucknow over the exact demolition itself, and also to make sure that the guilty are properly punished?
In last 2 years, the court tried its best. Justice Nariman gave very a strong worded directive to the judge that he must finish the trial. He did not. Now he has retired. The court has extended his service till April 2020, but I am not hopeful of much progress in that case. Even if it is decided in the lower court, there will be appeal in the High Court and appeal in the Supreme Court. I don't think that anyone is really going to be punished for such a major assault on rule of law and Indian Constitution.
And will that disappoint the Muslim community?
It would, because now it stands proved that Babur did not demolish Ram Temple, but the whole world saw who demolished a mosque on TV, live, and yet nobody is going to be punished.
And that will disappoint and hurt the Muslim community?
It may.
It may?
Yes, of course.
Not it will, it may.
It will, of course. It's common sense.
One intriguing question. What would the Supreme Court have decided if it was adjudicating the case in circumstances where the Babri Masjid was still standing and had not been demolished? In those circumstances, if it wanted to give it to the Hindus, would it not have to order itself either the demolition of the mosque or at least permit?
It would not have permitted demolition, and High Court would not have ordered excavation and ASI report. And that's why I feel that it's problematic as such to rely on ASI report.
But you're saying something else as well. When you say the Supreme Court would not have ordered demolition or permitted demolition, that means that if the Supreme Court was hearing the case at a time when the Babri Masjid was standing, it wouldn't have given the land to the Hindus.
It would not have given entire land to Hindus, of course.
So the whole complexion of the case and the outcome
Would have changed.
Would have changed.
Yeah. Because that's why I wrote...
The fact that the mosque ceased to exist made it possible to give the land to the Hindus.
Yes. And that's why I said that ideally, in my opinion, the court should have given possession to Muslims and then invoked 142 to say, since the structure is not there, we are giving this land now for the construction of...
In other words, the court should have first acknowledged
Yes.
that the Muslims have the title to the land, then using 142, those extraordinary powers said,
Right.
since the structure is not there,
Yeah.
however, we'll give it to Hindus.
I think that would have satisfied Muslims as well as secular liberal Hindus. You see, more Hindu liberals and secularists are far more disappointed with the judgment than the Muslims.
My last question, we've discussed several anomalies, inconsistencies, even illogicalities in the way the Supreme Court has handled this matter, particularly in the way the Supreme Court has adduced evidence and viewed what it calls a mosque as a place where still you don't have proof of worship. Given all of those inconsistencies, illogicalities, do you think there is a case for a review? Is the Muslim Law Board and the Jamaat-e-Ulema Hind right in wanting a review?
I'm not very sure, because review gives you a very limited scope. In fact, I had written somewhere that anyone planning to file a review should read Nariman and Chandrachud in Sabrimala. Both of them rejected the review because you really have to point out clear error on the face of it. The hearing will happen only in the chamber. But since it is a constitutional right, you see, you should not be protesting against judgments on the streets. Because if you have faith in the court, then you should not protest. Our constitution and courts themselves permits a form of a civil protest against a judgment, pointing out errors in judgment, invoking courts review jurisdiction. So if people want to do it, they can do it.
But you are also saying there's no real purpose going to be served by doing it.
I think so.
Particularly because the review will be heard by the same judges.
Yes.
And if
one more judge will come in place of Justice Ranjan Gogoi.
But chances are that that combination of judges, including the one new judge, will still stand by the original judgment.
I feel so.
Professor Mustafa, a pleasure talking.
Thank you so much.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.